Dear viewers, welcome back. Like many other pieces of EU law, the AI Act contains numerous annexes. Reading these annexes alongside with the related provision is important to fully understand the obligation contained in a regulation. All in all, the AI Act contains 13 annexes. Most of them, that is to say annexes 1 and 3 to 10, concern high-risk systems. The remaining annexes are mainly dedicated to general-purpose AI models or GPI models. In this video, we will delve into their essential contents. The first 3 annexes help to understand the very notion of high-risk AI and the boundary between high-risk systems and prohibited AI practices. The first and third annexes relate to classification of AI systems as high-risk. As a reminder, high-risk systems are product or safety component thereof, entering the scope of one of the sectoral EU Act listed in Annex 1 and simultaneously subject to a third-party conformity assessment under that EU Act. Systems used for a purpose listed in the third annex are equally high-risk. However, one must note that Annex 1 is split in 2 sections, A and B. This distinction is important as risky AIs qualifying as such under Section B, such as vehicles approval and civil aviation security, are not subject to the material requirements contained in the AI Act. The second annex of the AI Act lists 16 criminal offenses, such as terrorism, murder, or weapon and drugs trafficking. This annex is used to determine the scope of an exception to prohibited AI practices. Namely, this exception to the prohibition concerns the use of real-time biometric identification AI system in public spaces for law enforcement purposes, e.g., facial recognition technologies to identify and locate a suspect. For high-risk systems subject to external, that is to say, third-party conformity assessment procedures, technical documentation plays a central role. Such documentation must be assessed by notified bodies before systems may be placed on the market or put into service. Furthermore, for all high-risk systems, so irrespective of the applicable assessment procedure, the technical documentation should be kept at the disposal of national authorities after marketing. In this context, Annex 4 of the regulation details the minimal content of the technical documentation that provider must draft. Therefore, this annex enables providers to be sufficiently transparent about their AI systems vis-à-vis public authorities. For instance, the provider's technical documentation must contain a general description of the AI system, including its intended purpose, how it interacts with other AI systems, the hardware requirements in order to make the system runs, etc. It must also contain a detailed description of the elements of the system and of the development process. This imposes to the provider to disclose, among others, whether pre-trained models or tools were used to develop the systems, the main design and classification choices, the computational resource used to develop, train and validate the systems, information about the data used to train, validate and test the systems, and system testing and validation procedures. In the technical documentation, the monitoring, functioning and control of high-risk systems must be explained as well. This includes, for instance, the limitation of performance, degree of accuracy, and human oversight measures. As the regulation requires the documentation to be kept up to date all along system life cycles, it must also include the changes made by the provider through time. Last but not least, the technical documentation must include a copy of the EU Declaration of Conformity, the content of which is listed in the 5th annex. For SMEs, a simplified version of their technical documentation is nonetheless foreseen. The EU Commission is tasked with the mission of establishing a template therefore. Annexes 6 and 7 detail the 2 conformity assessment procedures provided for in the material provision of the AI Act for high-risk systems. Annex 6 describes the internal, so in-house conformity assessment procedure, whereas Annex 7 deals with the external conformity assessments. Let's focus on Annex 7, since Annex 6 was already discussed in another video. It stems from Annex 7 that providers must submit 2 distinct applications to a notified body. One concerns the evaluation of the quality management system, and the other bears on the assessment of the technical documentation. The specific information to be provided for each of these applications is detailed in the annex. Regarding the evaluation of the quality management system, the notified body must issue a reasoned decision on its compliance with the relevant provision of the AI Act. Later on, if the providers plan to modify its approved quality management system, he is required to inform the notified body of the desired changes. In turn, the notified body may decide to approve or deny the changes. Regarding the assessment of the technical documentation, the notified body will assess whether the AI system meets the many material requirements for high-risk systems. If so, the notified body will issue a certificate. Where it refuses to deliver one such certificate, the notified body has to provide detailed reasons for it, allowing the provider to implement the required modification. For instance, the notified body could impose on a provider to retrain his system before filing a new application. Finally, Annex 7 also sheds light on the power granted to notified body throughout conformity assessment procedures. Their powers include accessing the data used while developing a high-risk system, carrying tests, accessing the models and parameters of the system, and so on. Regarding Annex 8, 9, and 10, 3 points are worth highlighting. First, high-risk AI qualified as such under Annex 3 must be registered in a public database, at the exception of systems used in relation to critical infrastructures. In the registration process, specific pieces of information must be provided, the list of which can be found in Annex 8. Second, to participate in sandboxes, prospective providers of high-risk systems must register any forcing testing in real-world conditions in a database accessible to market surveillance authorities and the EU Commission. The information to be provided throughout the registration is listed in Annex 9. Third, Annex 10 of the regulation contains a list of EU acts establishing large-scale IT systems at the EU level. For instance, it contains the Schengen and Visa information systems. Risky AIs that are components of such large-scale IT systems benefit from a derogatory regime, thanks to which they must comply with the AI Act by the end of 2030 instead of August 2027. Annexes 11 and 12 both relate to the technical documentation of GPAI models. Providers of such models who release them under paid-for licenses must comply with these two annexes. They enumerate the pieces of information to be provided to two distinct types of stakeholders. On the one hand, the information referred to in Annex 11 is mainly intended for the AI office, although national authorities may also access it in some cases. On the other hand, the documentation referred to in Annex 12 must be available to providers of AI systems who intend to integrate GPAI models into their systems. Both must include a general description of the model and a description of the main features of the model and of its development process. More details are required under Annex 11 since its objective is to ensure the enforcement of the AI Act by the AI Office, whereas objective of Annex 12 is rather to allow for smooth integration of GPAI models in downstream AI systems. Finally, Annex 13 contains the list of criteria to be used by the Commission when it intends to designate ex officio a GPAI model as presenting a systemic risk. In that process, the Commission has to rely, among other things, on the number of parameters of the model, its adaptability, and the number of business and non-business users. The AI Act empowers the EU Commission to adopt delegated acts to modify the content of some annexes. The purpose is to ensure that the legal framework remains up to date in light of technological progress. Precisely, Annex 3 to 7 and 11 to 13 can be subject to modifications by the Commission. In practical terms, this means that, unlike the regulation itself, these annexes can be modified without the need for a vote in the EU Parliament nor at the EU Council. However, when the Commission amends an annex of the AI Act, it must immediately inform the Parliament and the Council. These institutions then have 3 months to reject the act adopted by the Commission. This is it for me. Please stay tuned since our last video will be released soon.